Hello again, Charles Cowap here. This is the second of our 4 presentations on blight and its impact on farmland and rural estates. In this presentation we're going to look at the procedures which govern the serving and administration of blight notices. In part 1 of the series of presentations we covered just what blight is, who's entitled to serve a blight notice, and in respect of what sort of property. Certainly worth looking at that if you've not done so already. Procedures then go like this. A blight notice is served on what is called the relevant authority. In any other field of compulsory purchase we would generally be calling this authority the acquiring authority, but because they've not quite got their fully approved compulsory purchase powers yet, they're called the relevant authority. But in short, they are the authority, government department or whatever, which would have compulsory purchase powers in due course. Once your notice has been served on the relevant authority, they have a choice of either accepting the notice, all well and good, or of serving a counter-notice. There's a 2-month time limit on the relevant authority for this, and if they fail to take action to serve a counter-notice within this time, then your blight notice will stand. There is nothing after 2 months that the relevant authority can do about it. Indeed, in my own professional experience, I have come across a situation where a relevant authority failed to take any action within the 2 months and was therefore stuck with the blight notice which it had received. There are a limited number of grounds on which the relevant authority can serve a counter-notice. That's what we'll look at now. So, their reasons for a valid counter-notice could include that they believe that there is no blight. You've simply made a mistake in serving your blight notice. They could also contend that you don't have a qualifying interest. Look back to presentation 1 to see the details of a qualifying interest, but this may be because you're not the owner-occupier of a dwelling house, or your commercial property is of too great a rateable value, or you're not the owner-occupier of commercial property or a farm. They can also contend that you have no interest in the property at all, or indeed that they have no intention to acquire it, or no intention to acquire it in the next 15 years. The consequence of that for the relevant authority is that they are then time barred from buying the property from you. The idea of this, I suppose, is to give some confidence in potential buyers of the property that compulsory purchase won't be affecting it in the reasonably near future. The last reason on this list is that they intend to buy only part of the property. That, as you can imagine, could be very frustrating for the property owner who wishes to avail him or herself of the blight procedures, perhaps because they've had a job offered in a far part of the country, or they need to move to look after elderly, infirm relatives in a distant part of the country, and clearly they want to sell their entire property. They don't want to sell just part of it or whatever. So to get a counter notice saying that the relevant authority only intends to buy part of the property can be very frustrating indeed. But this is not the end of the blight procedural story, because if you are in receipt of a counter notice, you can then refer the matter to what we used to call the Lands Tribunal, we now call the Upper Tribunal Lands Chamber. Again, there's a strict time limit. It's 2 months once again. The claimant must refer both their original blight notice and the relevant authority's counter notice to the Upper Tribunal Lands Chamber. It's then up to the Chamber to decide whether it will confirm the validity of the blight notice in whole, or where the relevant authority has contended that it will only need to purchase part of the property for that part of the property. So this is the line of defence if you receive a counter notice to say that only part of the property is required, but in your mind you need to sell the whole of the property sooner rather than later. So let's have a look at a little exercise now. You might want to just take in these questions and pause the tape for a minute or two while you think about the answers. The first example is a dwelling. It's in Band E council tax and it's let on an assured short-hold tenancy. The second is a dwelling, Band C council tax, owner occupied by a new owner who moved in only 3 months ago. The third is a dwelling in Band D for council tax, and it's been empty for 13 months, other than the storage of some tools and so on in the garage and a garden shed. And the final one is also a dwelling, Band C council tax. It's been empty for 11 months. As I say, you might want to pause the video for a moment or two before hearing the answers to these questions. The answers then. The first one, there is no owner-occupier because there's a tenant and there's an owner who's not in occupation. No blight protection. Secondly, the owner-occupier only moved in 3 months ago. He's not been there for the full 6 months yet, so no, he doesn't benefit from blight protection. The third one, been empty for 13 months, that's left it empty for too long. Once it's been empty for 12 months or more, it no longer benefits from blight protection. The storage of some tools and so on in the garage doesn't count as owner occupation for this purpose, as one leading case demonstrated. The fourth one is actually the only one on this list which would count for blight protection. It's only been empty for 11 months, but in another month's time it will fall out of protection as well. And of course that is on the assumption that the person who has left it empty for 11 months was indeed, still is as far as blight is concerned, the owner-occupier. The next thing to consider is the extent to which a blight notice would be served. Let us have a look at this property. We'll call it Blue Acre for obvious reasons. A new road is proposed which will go take part of the property, and there it is. The question, do you serve notice for the whole of the property or just the area affected by the draft compulsory purchase order? Again, you might want to pause the tape and consider this for a minute or two on your own. The answer here is that you serve the blight notice for the whole of the property. The idea of blight, the underlying idea of blight notice, is that owners who need to sell their property because they need to move for work or whatever other reasons, and yet find themselves quite unable to do so because of public development proposals, can serve a blight notice to bring forward the compulsory purchase of their property. The rationale, therefore, is that you're trying to sell the whole of your property, not just part of it, and it won't be a valid blight notice if you serve it for just the part. It's therefore essential in all cases that the blight notice is served for the whole of the property. This of course invites the relevant authority to serve you with a counter notice saying that they only require part of your property. At this point, as we have seen, you refer that counter notice and your original notice to the Lands Chamber of the Upper Tribunal. And then you build your argument around the definition of material detriment in Section 8 of the Compulsory Purchase Act 1965. Material detriment in Section 8 apply to houses, buildings or manufactories which might be required for compulsory purchase, and parkland gardens as well. If the remaining part is materially detrimented by the act of compulsory purchase or the proposal for compulsory purchase, then you can't be required to sell part of it if there's a serious effect on the amenity or convenience of what is left. So therefore you would argue in your case at the Lands Chamber that there is indeed material detriment to the land which is left over. There have been several cases on this concerning blight provisions, and the general tenor of them is that the Lands Tribunal, the predecessor of the Upper Chamber, has taken a fairly lenient view of what does and doesn't count as material detriment. The effect of the confirmed blight notice, once either accepted by the relevant authority or confirmed by the Lands Chamber, is that the relevant authority is deemed to have served a notice to treat in respect of your interest in the land. And that then opens the way to a compensation claim under the usual headings for compulsory purchase: the market value of land taken, or reinstatement costs in unusual cases where there's no general market or demand, severance and injurious affection if only part of the land is being taken in response to a counter notice, disturbance to cover removal costs and the like, and as well as that, home loss payments, at least since 1991 when the legislation was changed, as well as the basic and occupier loss payments which have been available since 2004. So that's the effect of a confirmed blight notice. You're now on a track which follows the normal compulsory purchase approach. It has to be said that there then can be practical difficulties in pursuing the claim at this stage. because although the relevant authority is deemed to have served notice to treat, there won't be any correspondence at this stage in most cases which actually looks like a notice to treat. So, another exercise to round off with, which of these commercial properties would qualify for blight protection? And like our earlier exercises, you might want to pause the tape for a moment or two while you think about the answers to these. The first is a supermarket. Owner occupied, it has a rateable value of £40,000. The second is a small corner shop. Rateable value £18,000. The lease has 18 months to go. Our next couple of examples concern an office which has got a rateable value of £25,000. There's a leaseholder who's got 4 years left on the lease, and there's also the landlord's interest. And our last example is a workshop. Rateable value £26,000, owner occupied. You might want to pause the tape here just to consider your own answers to these questions. And here are the answers. The supermarket exceeds the rateable value limit, no blight. The small corner shop, there's no owner occupation here because the lease has only got 18 months to go. 3 years will be required, no blight protection. The third one, our leaseholder with 4 years left on the lease, the office is within the rateable value limits of £34,800. The lease has got more than 3 years to go. Yes, the leaseholder has the benefit of blight protection. The landlord's interest, he's not an owner-occupier, so he does not have the benefit of blight protection. Fifthly, the workshop, owner-occupied, it's within the rateable value limits. Yes, qualifies for blight protection. Curiously then, of our 5 examples, only 2 actually qualify for statutory blight protection. So, we've looked at the procedures which lead up to a blight claim and the compensation which flows from the acceptance or confirmation of a blight notice. In the third of our 4 classes, we'll be looking at the particular situation of farms and planning blight and compulsory purchase. Thank you once again for your attention.